case that the policy was issued before the effective date of 627.70152. And there's also no question that rights under an insurance policy are controlled by the statute in effect when the policy is issued. That's at pages 12 and 14 of the initial brief, and I don't read Universal to dispute that. So the question, when we have a policy issued before the effective date of the statute, is there a clear retroactive intent? That is the standard under Devon, the latest case from the Florida
Supreme Court.
Let me
ask you this, is that the threshold issue? Under Love, is it possible to read Devon, the way that the order in which they analyze however many parts there are to this analysis as presuming the first step? Because under Love, a procedural statute, application of a procedural statute to a policy that was executed before the procedural change is not even retroactive application at all. So in other words, what I was saying is, in light of that explanation in Love, then Devon was setting up a series of points to cover in the analysis, but it was already presuming that only applied to substantive provisions.
Your Honor, when 627.70152 is read as a whole, it clearly has substantive parts that are implicated by the failure to give the notice.
Okay, well, then I guess my sub question would be, in order to get back to the question I want to address, is this an all or nothing? Is this an all or nothing proposition? In other words, Are there provisions that are procedural and that could be applied retroactively under Love, and then isn't then the Devon analysis only pertaining to those provisions of this bill that are substantive?
Your Honor, that's the mistake that Cole and now the third district in a case called Catens, I guess is how it's pronounced, that Ms. Russo filed this morning. It just came out this morning from the third. That's the mistake they made. The Hughes case analyzes it correctly, as did this court in May of 2022 in the trilogy of cases where it rejected the cert petition citing Menendez, and Judges Kuzana and Northcutt were on the panel that did that. And so we have, I would say, the second and the sixth deciding it correctly, and the third and the fourth deciding it incorrectly.
Explain what the mistake is. I'm presuming that you're going to say one of the mistakes is the all policies, but you're identifying a different mistake.
Well,
I think Mr. Elligott's referring to we denied relief based on citation to Menendez, correct?
Yes.
Which held that a pre-suit notice requirement was substantive.
Yes. Yes. And
you're making reference, Mr. Elligott, to the security first versus Stokely cases. That's what you're reference to. And
yes,
I think it was Judge Northcutt, me, and I think Judge Black was the third judge.
Stokely, Payton, and Fisher were the three cases, and yes, they all cite to Menendez. And let me kind of come back, because I think this is part of the confusion here, and where the third and the fourth guy have gotten off track. Is trying to, first off, is a cardinal rule, and Menendez says it, that you have to read the statute as a whole, okay? And the fallacy of saying, well, we can look at just the notice piece, and all it is notice, and I'll come back to that because it does have implications. All it is notice is false, because that's section 3. But then if you don't give notice under section 3, you get dismissed under section 5. Getting dismissed, starting to look pretty substantive. And when you get to section 8, it says if you were dismissed under section 5, you don't get fees. And as the statute recognizes in the case law, and the opinion, if you look at the concurring opinions in Sulzer, recognize the right to get fees is a substantive right, including for your time before you filed the suit. So you have to read these pieces together, and the case law is abundantly clear on that. You can't just parse out one thing and say, oh, that's just procedural. If it was procedural and it didn't have any impact on anything else, I understand that argument, but that's not the case here. So coming back,
just to entertain my argument, though, so you're saying that you have to read it as a whole, but speaking of concurrence, I think it was Judge Smith, he argued that the order was incorrectly described in Hughes, the order of analysis, and he said the actual initial determination has to be procedural versus substantive before you get to the question of whether there's a clear legislative intent. I'm going to speak for Judge Smith, but that's the way I remember reading it. And now, so leaving aside the as a whole question, am I correct that we only get to the clear legislative intent if we're speaking of a substantive provision? You don't need clear legislative intent to retroactively apply a procedural provision. Is that correct?
If you had if the only thing that was happening was applying a procedural change and it did not have any impact on anything else, anything substantive, then yes, procedural, I would agree. That would be, you would typically expect that retroactive. But that's not what happened here. Not when it's applied the way it's been applied.
And if I may, Mr. Elliott, here, I think the implication, there's a lot of implication within here. We're dealing, and I think you hit the nail on the head. It all is all entwined. The lack of notice will then trigger a dismissal, which then implicates the attorneys, and the attorney's fees is substantive. So you can't isolate or myopically carve out one thing because they're all are together. So out from our standpoint, I think the analysis is from the threshold that we need to determine is, does this deal with a substantive right? And if we're dealing with attorney's fees, we're dealing a change, we're dealing with that, this is what we need to look for in terms of the analysis as to whether or not something is retroactive or not. Am
Absolutely.
I correct?
Yes, absolutely, Your Honor. And it's beyond fees. Let me add to that, because if it talks, the statute does a lot of different things. If you look at, I think it's like pages 13 to 15 of the answer brief, where Universal's describing all the things you have to do, there's a whole bunch of new things you have to do. I mean, Menendez makes it clear that the notice provision there was impactful in a substantive way. It changed the rights of the parties. Before that, they could just file suit. And that's what you could do here. And that's a mistake. The Catan's decision that and I appreciate you haven't seen it, most likely because I haven't seen it. It didn't come out until this morning.
And just so you know, Mr. Elliott, we were able to pull it out. We have it right here in front.
Well, great.
Yeah.
And I mean, I think you'll see, to me, it makes all the same mistakes Cole makes. It says, well, it's all suits. Okay, I think Hughes took that apart and says, look, all suits is a type of case. It doesn't say, it doesn't talk about anything to do with timing. If you wanted to do timing, Menendez shows you how to do it. Menendez said it applied to all actions filed on or after the effective date. Okay, actions filed. If this was retroactive, that's what it would say. It wouldn't just say we have an effective date of July 1. Now, the other thing here's something that Catan's does that's a new mistake, if you will. I think a new mistake. They say,
and before you get to that,
yeah.
Didn't also Menendez hold, and I quote, that statutes with provisions that impose additional penalties for non-compliance or limitations on the right to recover attorney's fees do not apply retroactively? Doesn't that Menendez also say that?
Absolutely, Your Honor. And that, because it is all in the same statute, that's read together, and that exactly applies and prohibits this being retroactive. Now, Catan and Menendez says notice is a substantive, if you have to give additional notice, that's a substantive change. Catan says, well,
and beyond that, didn't the Supreme Court in Menendez also say that even if the legislature expressly states that this pre-suit notice requirement is going to be retroactive, if it affects a substantive right that existed pre-existing, the Supreme Court would not give effect to that retroactivity declaration?
Yes, that's absolutely correct, Your Honor. It would make it, to do so would make it unconstitutional. And we're not.
So from your point of view, I submit consistent with Menendez. Once we identify substantive rights that are affected by the pre-suit notice requirement, that's the end of the discussion.
Yes. As far as retroactivity goes, yes.
Right.
And to just finish a thought on, because I think Catan's is a little bit, this is a little more subtle. I think it's about page 7 of the opinion. They say they realize they've got a problem dealing with Menendez because, you know, the notice there, and they say, well,
And the Supreme Court.
as the Supreme Court, sure. And of course, let's not forget Devon, because some people have Cole tried to say, well, Menendez is just, you know, it was a PIP case. Well, Cole didn't cite Devon. I see Catan's at least cites it, but doesn't really deal with it. I mean, Devon's the latest case on that, and it shows it's a first party property case. So it applies directly here. But in Catan's, they say, well, unlike Menendez, there was no additional time given here to make a coverage decision. They said, because, you know, and they're saying that was a fault in Menendez, in the statute of Menendez, the insurer got additional time to make a coverage decision. And they say here, I'm sorry, I'm bouncing a little bit. They say that here, this notice isn't given until after the coverage decision. Well, let's look at that. After that, when you give the notice, the insurer gets 10 business days more to revisit its coverage decision. And if they want to reinspect the house, they get another 14 business days. So it is absolutely causing the same type of delay that Menendez did, and says you can't do that, that's harming the rights of the insured. So,
and by its term, Menendez by its terms did not limit itself to PIP cases.
Oh, no, it did not. And then the Supreme Court cites it a year or so later in Devon and says, you know, in a property case. So it clearly is not limited. Cole, like Universal's answer brief here, didn't cite Devon. So I have some more I could say. I'm happy to answer any questions. I think to do what, well, let me just briefly talk about attorney's fees for this appeal, because 627.428 under Florida Statute year 2020 was in effect when this policy was issued. So there is a fee claim here for the appeal, for the trial court too, but for the appeal. And if we win this appeal, we will be protecting the insured's rights. We will be avoiding a penalty, which would be the dismissal. And while it's not required to be entitled to a fee, we would also secure a monetary benefit for the insureds, because they won't have to pay a new filing fee to refile. So for that reason, if we do prevail, we would ask that the fee entitlement under 627.428 not be conditional, because we will have established these rights. With that, I would stop for now, and unless there are any questions, we'd ask you reverse. Thank you.
Thank you, Mr. Elliott. Ms. Russo, you're up. And you need to turn off your mic, turn on your microphone.
You're muted.
Here, Ms. Russo. You're muted again.
Sorry.
That's all right.
There you go.
You know what? I mess this up all the time. So.
Elizabeth Russo on behalf of Universal Property and Casualty. What this statute is trying to address is the fact that litigation is the most undesirable and least efficient way of resolving property damage claims. So this statute was trying to interpose an abbreviated, short, last opportunity to resolve without litigation.
That part I get. That part I get, but that part,
if they would have done that, Ms. Russo, wouldn't have just simply say, okay, just deal with only that issue. It's implicating a lot. I mean, as I talked to Mr. Elliott, it's like the notice then causes a dismissal, and the dismissal causes the issue of fees. And, you know, we're talking about policies that were entered prior to all that. And so it's not as easy as that. If that was their goal, they could have easily worded it in a different way. But as worded right now, it causes me concern.
Well, I would go further. I would suggest that Menendez says even if they had said retroactive, it couldn't be retroactive because of that impact on substantive rights that had pre-existed it. And so I understand what you're saying, Ms. Russo, in terms of what the policy of the legislature was trying to accomplish. But can it be for us to extend that policy as a court when the Supreme Court says that the legislature can't?
Well, I'm going to say yes, and I'm don't agree with the quite such a broad reading of Menendez. I understand that somewhere along the way in Menendez, they said we look at the statute as a whole, but what they really were doing was they started to look at the PIP statute as a whole.
But they didn't, when they declared the principles that govern their decision, they didn't say in PIP coverage these are principles. They used broad language.
Well, I may I just go through the actual.
Oh, you can go through. I'm sorry, I don't mean to interrupt.
No, I mean through the Menendez, because these were the things that bothered them in Menendez. The notice of intent was added to the PIP statute, where, as they pointed out, it is intended to provide for swift and virtually automatic payment so that the insured may get on with his life without undue financial interruption. The PIP statute had said 30 days from notice. We don't have any such consideration with property insurance. There's no pay in 30 days. There's no time limits for paying property insurance. In fact, it often takes a while, which is a shame, but it does. And this statute was trying to shorten that up if possible. The next thing that Menendez was pointing to was that it gave the insurer additional time to pay, and then it reduced the amounts of interest that were owing. It used to be under the old statute, or before they tried to amend it. Well, again, you have the 30 days to pay, and they made a longer period of time, and you got interest at 10% a year, and they collapsed that to $250 at most. Okay, both of those are substantive in the PIP context because they're taking away rights that mattered, that they already had. Here, there's no particular time to pay, and there's nothing about this statute that affects the interest that an insured can get, or for that matter, any of the insured's rights to collect under the policy. They're not affected at all by this notice provision. The attorney's fees, I will grant you, is a different story, but we briefed as has appellants, have briefed the severability concept. If there's or a portion that could not be applied retroactively constitutionally, that can just be left aside. We haven't really gotten to attorney's fees yet in this case, but as they said in Cole, just that can be severed. So you look at let's just try to see what's being accomplished with this notice provision and see if that can be applied.
But if I may, but in the statute, the notice provision, I mean, it's all intertwined. It's all, if you fail to do this, if you fail to do that. So we're not dealing with a notice statute standing alone. It's like you have all of those. So I'm having a hard time with the argument that it's severability.
All right,
Yeah,
let me address just the notice.
I'm concerned about the severability aspect of it. If you're saying, okay, you have a provision that, frankly, in Menendez, it would be unconstitutional because of its effect on substantive rights. And what you're saying is rather than finding a statute constitutional by severing out the notice provision that would be unconstitutional, you're saying you can take this unconstitutional provision and again act like the legislature and make it constitutional by excluding its operation on certain substantive rights. That's kind of like another step that I'm not comfortable with.
Okay.
In terms
I understand, Your Honor, but that's not what I'm saying. What I'm saying is that the notice provision, when you look at it by itself, is procedural in nature, and I'm trying to explain why it's different than the Menendez ones. For example, the notice itself, the notice that the plaintiff is required to provide in this case just has to say, what do you think the insurance company did wrong, and how much do you want them to pay you? How much for damages, how much for attorney's fees, how much for costs? That's it. That's all they have to put in their notice. And that's so that the insurer will have a number. Contrast that with Menendez. This is what they said. Menendez, they said critically, the notice of intent requirement itself requires the inclusion of additional information that the insured may not have had access to or may not have access to, and which may not be sent until the claim is considered overdue under the statute. That's a very different thing. asking for information they don't have. Here, you're just saying to the insured, what do you think the insurer did wrong? And what do you want? What money do you want? That's not an imposition of any kind. You would have figured that out by now anyway. If you're about ready to sue, you know what you think they did wrong, and saying, here's how much money I want. That's not a substantive burden of any kind. It's just getting the information to the insurer. Concomitantly, the insurer's duties are pretty quick and not very burdensome to the insurer. There it says, investigate quickly. They investigate all the time. That's what insurance companies have at their fingertips. Gives them 10 days. If there's a claim denial, you have 10 days to get back, 10 business days, sorry, to get back to the insured with either accept their claim, accept coverage for the claim that they've now told you that what they want, or keep denying. In which case the insured, if it's settled, great, then that's it. Mission accomplished. If not, go have your lawsuit. You can add a 14 days on if they decide they also want to have an additional inspection. So then it becomes 24 days, and then they have to accept coverage for what the insured has said is the amount they want, or say, no, we're going to continue to deny. If they continue to deny, it means there's a dispute over coverage. And so it's going to have to end up in the courts anyway. But either way, in 10 days or 24 days, the insured gets to file their suit. If it's not going to be resolved. If it's resolved, even better. That's the point of the statute, if you can possibly get it resolved. But if not, you lost 10 days or you lost 24 days. That's it, if there was a claim denial. If there wasn't a claim denial, that means that the dispute between the insurer and the insured or the claimant is an amount of loss dispute. So then it says, if there's not a claim denial, then the insurer has to either make you a settlement offer or go take you to appraisal. Making you a settlement offer, either the insured says, okay, good, yes, I'll take that, fine, claim is settled. If they don't, it's effectively a claim denial of anything above what was offered. They can go file their suit. Otherwise, they go to appraisal. It's a maximum of 90 days, cuts it off the time. If it's not finished in 90 days, then back you can go to filing suit immediately, it says. But in that 90 days, you can get the major thing accomplished. When there's not a coverage problem, you get the amount of loss determined. And now the parties have their number of what needs to be paid. So either
arguably, Ms. Russo, you're describing a bunch of substantive provisions that, under the guise of procedurability. And I'm not going to dispute, the efficacy of the policy. If the question is whether it can be applied to a contract that existed prior to the statute. And I think you're describing, the legislature has set forth this procedure that does involve some substantive rights. I mean,
if I may, I think that the procedures that I've just described, like appraisal, is already in insurance policies. That's where the appraisal.
I get. But what you're saying is if you don't do this notice to kick off this procedure, you get kicked out of court. You can't get your fees, and this procedure itself is involves some substantive rights. That
I'm not sure that it does. It's just trying to get a claim.
Well, a requirement that the insurer make an offer. But
that's the insurers are not complaining about this or claiming.
Well, I get that. I get why. Yeah, I wonder why that is. But
because they want to get the claim settled without litigation.
Of course they do, but they don't necessarily have the right to impose that on pre-existing contracts. That was the point of Menendez, I think.
Well, but what it looks at are these new substantive duties or substantive rights that are being taken away? Because if so, I agree with you, then it can't be applied retroactively. But here, it's just, we're going to take a short period of time with the same contract obligations and mechanisms that we had anyway to try to reach a number.
Another way of characterizing what you're saying is that all of those provisions you just described are methods of conducting litigation involving the right. So could you tell me what you think the right or the rights are that are not being altered? In other words, I'm making a counterpoint. I'm saying, you've described methods of conducting litigation involving that.
Claims
But I think your obligation, given Menendez, is to tell this court what you think the rights are. One right is the right to attorney's fees, but then break that off from what you're describing, which could be conceivably described as methods of conducting litigation involving that right. So just break it down for me. What are the rights that you're saying are not altered, and what are the methods?
Okay, I'm saying the rights that are not altered at all by this short process are your right to collect under your insurance policy. Nothing about your claim, here's my policy, here's what I'm owed, here's what it says, all of that is left unaffected. You're perfectly entitled to collect on your claim, whether you do it through this short process or whether you end up in litigation. That's unaffected. You are also not in any way prohibited from going to suit. In fact, it says multiple times, if this doesn't work out, you can go to suit immediately without further notice. So I don't think that there's anything about this exchange of information and offers and trying to get it settled that affects any substantive rights. Now, the other two sections that have been talked about are if you don't file this notice ahead of time, then you're going to get, there's going to be a dismissal without prejudice for you to comply. I don't think that's the right way I don't think you look at it as, okay, well, if a party violates the statute, what happens? The question is, if they comply with the statute, are any of their substantive rights taken away? Because that's all you have to do is comply. If you have no complaint with the substantive complaint with the statute, there's no problem with just going forward with it. Or for that matter, any statute that has provisions is going to have some kind of consequences if you don't comply. So you don't look at, if I violate this statute, what's the substantive effect? Or that's a substantive. No, if I comply, have I been set back? Have I lost any substantive rights? And the answer here is no. So I don't think that's that.
Okay, well, so I could follow that argument and say that, yeah, that is just the course, form, manner, means, method of order, process, or steps to enforce. And so, but and say that, yeah, so I only analyze it based on if I do all those things, I still have the right. But it isn't under Menendez. Correct. You give me your counterpoint to what I hear from the opposing party and other members of this panel that say under Menendez, that's not the way it's analyzed. Even though, yes, if I look at the test and I can say, yeah, this is the course, form, manner, means, method, and this is just the means of conducting litigation. If you do it the way the legislature says you have to do it now, the procedural way, you have all the same substantive rights. But is that consistent with Menendez?
I think
doesn't Menendez say that? Well, the consequence of not complying with this new procedural hurdle is something that needs to be considered in whether this is a substantive change.
Well, certainly, but I think in Menendez, back to their notice of what you look at in each case is you start. I think the analysis is the two prongs. First, was it intended to be retroactive? If there's a question about a retroactive application, and then second, if it was intended to be, then we get into, well, what are the changes affecting? Are they affecting substantive rights or are they procedural? If they are affecting substantive rights or creating new substantive obligations, then you can't apply it retroactively. I totally agree.
Okay, let me ask you this.
Here really is.
I have a question that, we have, at least on 3 occasions, denied petitions on the merits on this issue, citing Menendez. In order to rule in your favor, do we need to go en banc?
No, I don't. I don't.
Why would that not be a conflict in our decisions?
I don't think just a citation denial petition has a precedential effect.
I'm not sure that's true. I know but even whether it has precedential effect, I don't think the en banc rule is to maintain uniformity in our precedents. It's to maintain uniformity in our decisions. And we have issued 3 decisions in property insurance cases applying Menendez to apply Menendez. And so that kind of, we clearly in those cases, if the argument was made, we rejected the argument that Menendez was limited to PIP.
I'm sorry, I'm looking at my, I know I looked at.
You're looking for the rule. I know, I get it.
The answer brief. And
I hope I'm wrong. I hope I'm right.
And actually, just that was going to be a question that I was going to ask Ms. Russo. So you took the question right out of me.
okay, I'm reading from my page 30 of my brief, but it says, because of the limited and discretionary scope of review of a writ of cert, a simple denial of certiorari is not an affirmance and cannot be construed as passing upon any of the issues. Now, it may be that having the citation makes
is that not in the context of issue preclusion? The question is whether that issue can be raised on a subsequent appeal from a final order. And the Supreme Court has ruled that the denial of any petition without comment is not issue preclusive. However, if there's anything that suggests that the court considered it on its merit, and one of those things would be a citation to authority, that decision is issue preclusive. Now, I mean, we have made the decision on the merits that Menendez applies to these situations. I have some concern about whether this panel could rule to the contrary without, en banc proceeding.
Well, I understand the question,
and I'm asking for your input because ultimately we may not have to get there, but if we do, we'll decide that internally. But
yeah, I understand, but I think if what I am saying is being entertained, and if you had to go en banc, then I think that's the position we're taking.
That we need to get away from this idea that Menendez controls this question for property insurance.
Well, I think so. And by the way, I think it's Devin. Everybody's calling it Devon, but maybe it is. Devin decided that it didn't get into the substantive versus procedural at all. It said this statute, it went with the first prong. Is there any indication in the statute that there's an intent that apply retroactively? No, there's not. It's silent on the subject. And all it says is it has an effective date. And where there's no other no statement in the statute that it's intended to apply retroactively, then if it just says an effective date, that's presumed to mean that it won't apply retroactively. So since we're ruling on the first prong that there's no intent for it to apply retroactively, we don't reach the second prong. So they didn't get into the merits of substantive versus procedural at all.
I think according to Judge Smith,
go ahead. Oh, go ahead, Judge.
I think Judge Smith on the 60C might differ with you if I understand correctly.
Yeah, I'm sorry. I don't mean to interrupt. I'm sorry.
Well, no, I mean, so you're going to have, I'll get that, and this goes to what I was asking Mr. Elliott, is that isn't it possible, given that procedural, isn't it possible that the procedural versus substantive question does precede the analysis of whether there's a clear legislative intent, and that for Devin, because of the way a lot of the verbiage indicates that they had made a determination of procedural versus substantive, that it just is presumed before getting to the intent question that they're only trying to ascertain intent as to substantive provisions, because it doesn't even matter for procedural provisions?
Well, I saw that was Judge Smith's analysis of it, and I went back and read Devon because of that. But I really think that they were clear in their bottom line in saying, we reiterate that we're using this two-step process. Step one is there an intent? Step two, is it if yes, then substantive versus procedural. And we're not reaching number two.
We have really helped you use up your time.
Oh, sorry.
That's all right. You're good. And so I'll turn it over to Mr. Elliott for rebuttal.
I thank the court.
You're good. You stop with about 6 minutes left to go.
Thank you, Your Honor. To sort of work in reverse, Devon or Devon, whatever it is. That was a statute, 2005 statute, that required notice of mediation, that the carrier, sure, there had to give notice of mediation to invoke a contract appraisal right, a simple notice. And yet that either way, we get the same result. Either that's substantive, the notice is substantive, a simple notice, tell the insurer you have a right to mediation before we get to appraisal. The insurers challenged that and they won because that was too much of a burden on them to do that, a simple notice provision. And then, yes, they look at the wording and they say, there's nothing there that evinces a clear retroactive intent because simply having an effective date is not sufficient. We've talked about fees are clearly substantive. These other things are substantive too. You do have to do more. You have to generate and attach reports. You look at section 3. But the other thing is there was a reference about, well, this is really no delay. There's no time limit. Well, there is a delay. Acknowledge a delay of 10 business days, 14 days. That puts you at about 30 days, which is about what the fifth one was in Menendez. But if you look at section 3 on notice, it refers to may not be given before the insurer has made a determination of coverage under section 627.70131. That is a different section of the property insurance statutes, and it contains time limits for the insurer to respond, to acknowledge a claim, then make a decision. And there's some situations where they can get additional time. So this is time driven. That's not a way this can be distinguished. I would agree that that under this, and there's some cases cited at the end of the initial brief where if this panel, of course we would hope you will stay the course, as to use the expression, but if you were to decide, oh, let's go, we want to change this and go, I think you would need to go en banc. We've cited a couple cases that basically say that in effect, because they were cases, the Fisher case was a case where they went and the court purposely went and looked at a PCA and a citation PCA and said, here's why our case that we're deciding is different and we don't have to go en banc. So I think that's the way this court has approached it in the past. I have nothing else unless there's some questions.
Well, that's it for me.
Thank you. We asked you to reverse. Thanks.
Yeah. Thank you both very much. Yet another interesting case on our plate for today. In order to leave our